Good afternoon, everybody. Thank you so much for joining us today. My name is Molly Ackland and I'm the Content and Communications Manager here at MorePay. So it's my pleasure to introduce the topic for you for this session this afternoon, which is on the King's Speech and the employment implications. So in terms of the agenda for the afternoon, Mike is going to start off by giving you an overview of employment implications, and then Gill will go through the employment bill, and then we'll have a look at beyond the employment bill and discuss a few other bills to be aware of. Gill will then cover the hangovers before we finally move into the Q&A section, where you'll have an opportunity to ask Gill and Mike any questions you may have. So if you're wondering how to ask a question, you may have noticed that your microphone is on mute, but we do want to hear from you. So please do drop your questions into the question panel shown here on the screen. We've had a really incredible response to this webinar, so I imagine we'll have lots of questions, but Gill and Mike will do their best to get through as many as they can at the end of the session. And on another note, if you're facing any technical difficulties, please don't worry too much. We'll be sending you all a recording later on this afternoon, as well as the slides. However, if you are facing any technical difficulties, please do flag it in the question panel, because if lots of them come flooding through, then I'll know that there's an issue on our end and I'll do my very best to fix it. So before I hand over to Gill and to Mike, I'm conscious that we might have a few people on the webinar that aren't familiar with MorePay. So I'm going to give a very brief introduction. Okay, so we provide payroll and HR software, as well as outsourcing services to UK businesses. We've been around since 1966, have all the accreditations you'd expect, and we're rated excellent on Trustpilot. Our promise is to make payroll and HR easy, and here's how we do it. So we've built payroll and HR software that's easy to use. We deliver quality outsourcing options, and all of this means worry-free compliance for businesses. On this slide, you can see some of the businesses who trust us to take care of their payroll and HR. And did I mention that we're award-winning? We've won the Rewards Payroll and HR Software Product Award 2022 and the CIPP's Payroll Service Provider of the Year 2023. So that's enough about us. Let's meet today's presenters. So I'll start off by introducing you to our presenters today. We have the lovely Gill and Mike with us this afternoon. So Gill has over 25 years of HR and employment law experience, whilst providing HR support and services at the most senior levels. Gill's experience includes mergers and acquisitions, complex 2P transfers, organisational development and strategic change management, as well as complex employee relation cases. So Gill currently provides HR support and commercially focused solutions to clients from a wide range of industries, including large high-profile organisations and SMEs. She works in partnership with line managers, senior operational managers, directors, employee and trade union reps, to successfully deliver a variety of business agendas. And we also have Mike with us today. So Mike is a senior HR consultant here at MorePay. He's responsible for the developing of employment documentation and is an employment law advisor. So Mike has over 30 years of senior management and HR experience, and he's managed teams of between 30 and 100 employees and is familiar with all the issues that employing people brings. He's also served as a non-executive director on the boards of several social enterprises and undertook a 5-year tour of duty as executive chair of a £30+ million annual turnover government agency. So, good afternoon, Mike. Without further ado, I'll now hand over to yourself to get started on today's webinar.
Well, hello everybody, and thanks for joining us. This has been a very interesting couple of weeks, and I'm sure one which has got us all really wondering just what the future is going to bring. Obviously, you will have seen that the government has published a wildly impressive and exciting in some ways and demanding in others legislative set of proposals, 39 in all, only some of which deal with employment and one of which is specifically an employment rights bill. And we're going to dedicate our time this afternoon to looking at the employment implications, or at least some of them, as many of them as we know. So just looking quickly at this slide, I think the first thing that I would want to say is this: despite the fact that all the adverts are this is going to change things within the first 100 days of the new government, that you can relax a little bit. It won't. It doesn't mean that just because we've got an ambitious government that they're going to change things overnight and just arbitrarily impose solutions, even though in certain cases they probably could. And arguably one or two of the more contentious issues that they've proposed, such as unfair rights from day one, are far more likely, although they could do that at a moment's notice, to take considerably longer. And that's because, as the second bullet point was clear, Keir Starmer is on record as saying what he favours is the more European model of social partnership between businesses, working people and trade unions. So there will be consultation on key issues. And that means that in reality, a lot of the legislation that even now is being proposed and we're thinking of, oh God, this is going to happen in 100 days, is far more likely to take a couple of years to roll all the way through. And indeed, some of the bills that we're going to talk about today are styled as draft. So that's a little hint to say we're thinking about this, but we're not really 100% sure where it's going to go. But as I say, 39 bills and a massive amount of proposed alterations to what we've been used to since about 2010 means that it's going to be a very, very busy time for every employer and for all of our clients, and indeed for ourselves as your advisors.
Perfect. Thank you so much, Mike. We're now just going to hand over to Gill to run through the employment bill.
Okay, so the first one is about day one rights to challenge unfair dismissal. So currently employees are required to have a minimum of 2 years service to be able to make an unfair dismissal claim. So this often allows employers the opportunity to shorten the disciplinary process for those with short service. The bill will put a stop to this by removing the qualifying period to allow employees the right to make a claim from their first day of employment. So the idea behind this is to encourage more employees to switch jobs, as this often leads to high wages and therefore productivity growth. Wages are usually around 3 times higher for those who move jobs compared to those who do not. The bill has made reference to continuing to allow employers the benefit of having a probationary period to assess the suitability of new starters, which implies a shorter dismissal process may be possible for those who fail probation, but there is no guidance on this as yet. And there's also no mention on what procedures will be required to end any temporary, seasonal or casual work contracts. The next point is about banning exploitative 0 hours contracts. The 0 hours contract can be a great tool to allow employers the flexibility to schedule the amount of staff required to be in work in line with fluctuating levels of demand for their services. And this suggestion is not to ban 0 hours contract, but more to ensure that they work for both the employer and the employee. At the moment, it's common for employees to be placed on these non-committal 0 hour contracts that do not guarantee them a set amount of hours each week, but in practice, they are expected to work regular hours. This often means that employees are expected to be available for work, but there's no guarantee that any work will be offered. This bill is set to stop this by ensuring that all employees have a contract that reflects the actual hours that they work, and that will be taken over a 12-week reference period. This will provide additional security and predictability for those workers on a 0-hour contract. The next part of the bill is about parental leave and sick pay from day one. So under current legislation, employees who take time away from work due to illness are not entitled to any form of payment until the 4th day of absence. And those who earn less than the lower earnings limit, currently set at £123 per week, are not eligible for any payment at all, regardless of the time that they are away from work. So Labour believe that this current practice is complex, outdated, and fails to adequately support those who need it. The bill will make SSP available from the 1st day of absence and remove the lower earnings limit. And they've taken a similar stance for parental leave by removing the requirement for employees to have a year's service before being eligible for parental leave. The new legislation will make it available from their 1st day of employment. Making flexible working the default from day one is another part of the bill. So flexible working legislation was originally introduced to actually help employees manage childcare arrangements, and this was changed with the aim to improve just a greater work-life balance for all employees who had more than 26 weeks service. The minimum service requirement was removed from April this year, and Labour plans to build on these provisions, with the main thing being that employers will be required to accommodate reasonable, flexible working requests. So this still means if a request does not work for your business, for example, if you've got a request from your bar staff or say nurses asking to work from home, you'll still be able to reject these as that's just not going to work for your business, but you are likely to need greater justification than what you do at the moment when rejecting any such requests. Another bill is about ending fire and rehire and the fire and replace. So I don't know if you remember, towards the back end of last year, there was an incident with P&O ferries where employees were told via a virtual announcement that P&O were no longer able to continue paying them in line with the current terms and conditions. So they were ultimately given the option of accepting lesser terms or being made redundant. So this bill is set to put greater controls in place to stop this practice happening. Another bill is a fair pay agreement for those who work in the adult social care sector. So this bill will focus on improving terms and conditions for those in that sector, including better working conditions, training and progression opportunities. Currently, this sector has a turnover rate of nearly 1/3 and a vacancy rate of nearly 10%. And Labour believe that this recruitment and retention crisis is a key driver of the crisis that we're facing, that face our NHS. Protecting new mothers is a new bill. It will be unlawful to dismiss a maternity returner within 6 months of their return. Now, there's little detail at the moment on what the protections will entail, but we can guess that this will be tightening up legislation around ensuring that maternity returners do not suffer any detrimental treatment on their return from leave, such as if there's any change to the job roles or if they're being penalised for things like taking time off to attend the sick child. Okay, and back over to Mike.
Okay, here's the scary ones. Everyone's a bit paranoid about trade union activity, and as this heading says, removing restrictions on trade union activity. Let me immediately say that this is not going to translate that there are going to be union officials banging down the door of your business a week on Monday. It isn't like that. What this is really about is some of the really contentious industrial relations situations that we've seen over the last few years particularly in the likes of the health service, the railways, for instance, and on a more general basis, big organisations such as motor manufacturers or some of the big retail organisations, the Tesco's, the Sainsbury's, the Amazons of this world. And it's about removing some of the difficulties that have been imposed in recent times by the previous government. What they're very keen to do in the new government is to establish this more European model where life revolves in the workplace around good faith negotiating and bargaining. But it principally is something that the unions are only interested in the very big fish. So if you're a small or medium-sized business, this is not going to be a great big problem for you. But what the government plan to do is to take out the recently or relatively recently enacted legislation that required a minimum service level where there's industrial action. That hasn't actually been, although the legislation has been in place, it hasn't actually been utilised. So I don't think employers are going to miss something that they haven't really valued. But it will mean in the brave new world, if we all sit around the table together, that there'll have to be a difference in the way bargaining goes on, particularly in the public sector, than it perhaps has in the recent past. And likewise with statutory recognition, this is talking about providing a reasonable right for people to access a union within a workplace. Now, a worker already has certain rights, to join or not join a trade union, and individually they can have somebody to hold their hand or represent them in, say, a disciplinary. This is not changing any of that. But there is already a formula by which any organisation that's got more than 20 people working in it and claim to have an interest from a union or demonstrating a wish to be part of a union can go through a body that you, in the main, I would imagine, have never heard of, called the CAC, the Central Arbitration Committee, and seek for that union to be recognised to undertake what is called collective bargaining within the workplace. So trying to negotiate better pay, better working conditions, and so on and so forth. The reality of life is that the unions are not particularly interested in small businesses. They are too difficult to organise into. And although perhaps in days of the current levels of technology with smartphones and Zoom calls and the sort of discussions we're having today at distance, that might change over time. Certainly for the time being, it's unlikely to be of much interest to the current crop of unions. So it remains to be seen exactly what this is going to translate as being, but we can't see at the present time that an awful lot is going to change, other than perhaps bringing the creaking Central Arbitration Committee a bit more up to date, allowing for things like electronic balloting and those sort of measures. It's not about, as I said to the earlier issue, people banging down your door next week to say we want to bargain on behalf of the people that work in your workplace. And even if they do come knocking, there would have to be a proper secret balloting procedure, and that by no means, even with big organisations, guarantees that will be what the workforce wants, and they may well reject the union even at that stage. One thing that is different and interesting is the idea of the prospect of a single enforcement body, which is being termed the Fair Work Agency. Now, you're probably all familiar with ACAS, which, let's spell out the letters: advisory, conciliation, and arbitration. So that doesn't say enforcement, and that's the important difference. Add to that employment tribunals, where, as Gill said earlier, if you claim to be unfairly dismissed, currently you have to have at least 2 years service before you can even go there. And if you do go to an employment tribunal, certainly in areas like Greater London, the chances are it will take up to 2 years for your claim to be processed and actually get before a tribunal. And it's dreadfully, dreadfully expensive and time consuming on everybody's part. So you can understand why they want to do something about that. There are a number of organisations that are involved vaguely in enforcement. So you'll see organisations like the Equalities and Human Rights Commission coming out with judgments. You'll see the Low Pay Commission coming out with views as to what low pay should be, what the minimum wage should be, and so on. We don't have the detail of what the Fair Work Agency will actually be yet, but it will be looking to be, I believe, more of an enforcement body, perhaps in the way that if we look slightly across the sea to Ireland, the Workplace Relations Commission there perhaps operates. They may be looking across. Some of the things that are in this legislation have certainly close sort of look very closely as though they've been looking across to Ireland, which is unusual. It's quite often the other way around. But the Workplace Relations Commission can send an inspector into your premises. They can, very recently, their law has changed so they can actually issue a spot fine. So we don't know, and I'm not for a minute saying that's what's coming. What I am saying is I wouldn't be surprised if they're looking at something with a bit more teeth than what we currently have. Okay, a little bit more now. Obviously, there's an awful lot of stuff beyond the employment bill itself, and Gill's going to cover a couple of them. Will cover a couple of them. Bear in mind what I said earlier, there's 39 pieces of legislation and the employment bill is only one of those 39. So we've got some more where there's likely to be an impact. And one of those is the Digital Information and Smart Data Bill. I think we're all only too familiar with the risks that are going on at the present time. You see the way in which people's profiles are being hijacked online. People are being misled, missold, very credible looking websites that you pay money over for a product, but you don't actually get it because it doesn't exist. All of these sort of things. We're not exactly sure what's going to come out of the pot in terms of what's going to be in the Digital Information and Smart Data Bill. One of the things that it appears it's not going to be is an artificial intelligence bill. Now, that's unusual and it may change. Now, the reason I say that is because Keir Starmer's government is also saying we want not to reinvent Brexit, but we want a closer relationship with Europe. Now, in the main, that's going to be about issues about immigration. It's going to be about issues such as security. It's going to be about tariffs. It's going to be about air travel. But it could well be that because Europe is already looking at having a bill, or no, it's now a law, it's an act within Europe that prescribes how artificial intelligence is going to operate, that we may get drawn into that sort of mix. We simply don't know, but there is no artificial intelligence bill. But at the moment, there are many aspects of artificial intelligence which can affect the employment scenario. Now, that can be widely used in the employment processes. It could be used for the monitoring of sickness. And that takes me on to the second comment there, which is if we just take one example, the dreaded GDPR, data protection. At the moment, there's a clause in the General Data Protection Regulation that says you cannot have automaticity. And by that, what they mean is you can't leave a machine or a computer to determine somebody's fate, whether that's their sickness record, whether that's their engagement, their employment, or whatever it may be. There must be human involvement in that. Now, the previous government was wanting to walk some way away from that, which could have meant that the current arrangement that we have with Europe, where our UK version of data protection is sufficiently close to the European version, for there to be an adequacy provision between Europe and the UK that means that we both recognise each other's versions of GDPR. And the previous government was wanting to free up a lot of things and allow a little bit more leeway, and that was getting reactions from Europe to say, well, if you do that, then we may well bring the adequacy provisions to an end. And as I say, this is just one example of where this government is wanting to move it back towards a more cooperative approach with Europe, because I think anybody can recognise that if the reality of moving away, for those of you who have businesses that are either owned outside of the UK or are doing business with the rest of Europe or part of Europe or the wider EEA area, the last thing on earth you want is to have to observe one set of GDPR for the UK and yet still have to recognise the GDPR for Europe for the other parts of your businesses. So one hopes and assumes that that's an example of the way working with Europe, not in Brexit or un-Brexit Mark II would work, but rather simply recognising that that's a very big economic partner for us, and we want to be able to work with them far closer than has happened of late.
Yeah, so we'll just look at some other bills that they're proposing. So there's the Equality, Race and Diversity Bill. And what that's hoping to do is to build on the success of the gender pay gap reporting and make it mandatory to report on disability and ethnicity gaps within the workforce, and encourage employers to take action to close them gaps. There's also the pension schemes bill, and this is set to continue in the direction of the previous government. The bill aims to tackle the lost pot problem by automatically bringing together smaller deferred pots into one place, so making it much easier to transfer and combine pension schemes like they have in the similar vein as they have to changing bank accounts over and things like that. It's now much easier to switch accounts. It'll be that sort of process where we'll be able to switch pensions, combine pensions much easier. And it's suggesting doing that, it's going to beneficially impact 15 million people and result in contributors benefiting by up to an extra £11,000 over their working life. There's no mention of measures regarding changes to automatic enrolment, trustee investment duties, or pension tax relief at the moment. There's the Skills England Bill, which has been introduced to address the issue of skill shortages. It is set to bring providers together, unions and other bodies, to try and boost skills training and tackle skill shortages to support sustained economic growth. And we expect that to address some of the concerns that we have with apprenticeship schemes at the moment. Sometimes people might feel that apprenticeships can get maybe taken advantage of. So we just want to build them to make sure it's a fairer scheme for anybody on an apprenticeship scheme, and that they're also getting the skills that we need as an economy. And they're hoping that the workforce is able to adapt and embrace these emerging technical changes. Okay, so just to talk about these, what we call hangovers, really. We've got, over the last couple of years, a number of private members' bills were enacted, some such as career leave and improvements to paternity provisions made it through and are now operational, but others required secondary legislation, codes of practice, statutory guidance, etc. before taking effect. And we're unsure at the moment as what's going to happen to these. In certain cases, such as the Tipping Act, final implication was deferred, supposed to be October this year, but there's still no statutory guidance has emerged. So there was some other legislation that was delayed to allow employers longer to prepare for its introduction, such as the reintroduction of third parties being included in non-harassment legislation. And at this stage, we do not know if any of these provisions have changed, if they've been repealed, or if they will go ahead as planned. As most of the legislation has received royal assent, it may be possible to fast track anything that remains by ministerial sign-off. However, it remains to be seen what is actually intended. So obviously we'll keep abreast of these issues and keep you informed of any information we have as and when we get it.
Wonderful. Thank you so much to Gill and to Mike as well. That was really insightful and quite a hard topic, as you know, a lot of it's up in the air at the moment, and we don't know for sure what's going to be happening. So thank you both. So we are now going to move into the Q&A section of this webinar. So please, if you have any questions that you'd like to ask Gill and Mike, pop them in the question panel, and we've got quite a bit of time to go through some questions. So yeah, pop your questions in. Okay, we'll start with the first question, which is, how will the proposed changes impact gig economy workers and freelancers?
So I'll take that one. So the bill actually includes plans to support self-employed workers by strengthening their rights and protections. So some of the things that will include is giving self-employed workers the right to have a written contract and allowing them to take more action to tackle things like late payments, extending their health and safety and blacklisting protections for all self-employed workers. So there is proposals there to also help that group of workers.
Lovely, thank you, Gill. Our next question we have, I think someone just wants to clarify, what does it mean by parental leave? Is this paternity and maternity or parental leave? Mike, would you be able to answer that one for us?
I shall try. It's so often going to be the situation today where we're saying we don't really know. And let me explain. There is a type of leave called parental leave, which is virtually unused, which gives you the right, and goodness knows how you actually manage it, to up to, I think, 18 weeks leave until, it used to be until a child was about 10, and I think it's now until a child assumes adulthood, so 18. However, it's virtually unused. So it might just be limited to having a look at that and making that more realistic, possibly giving it a week with pay, who knows. But it could also be a recognition that shared parental leave is also just not simply working. It is used, but it's used minimally, and it's extremely complicated to try and administer. There are other forms of leave which might apply to parents. So you will know that you will get the odd occasion where a school closes. That might be because the boiler's blown up or the roof's caved in, or because the teachers are on strike and people in your workforce are saying, I need to take a couple of days to sort out care arrangements for my children. So it could be about that. But it's not going to be a fundamental revision of maternity provisions as best as we're aware. It's going to concentrate around parental leave, but it will be more a case of where the clock stops, whether it's going to include parental bereavement leave, which was relatively recently added, whether it's just parental leave, the official designation, whether it's shared parental leave or what. So sorry I can't be more definitive on that one, but it's going to be a wait and see on that, I'm afraid.
Yeah, that's great, thank you, Mike. Okay, we've had quite a few questions come in. So next one for you is, in terms of flexible working, can you say no to a flexible working to an office worker who is able to work from home, but it is company policy that we don't offer this on a permanent basis?
Do you want me to run on with that one? I think the simple answer is no, not just as that is. If you look at the legislation, if you're with More Pay, in the employee handbook that hopefully we've worked with you to provide, it will set out there are approximately 7 business reasons by law as to why or when you can refuse, and they've got to be strong business reasons, and the reasons for them are set out. But if I understand the question correctly, if that's saying we don't offer it on a permanent basis, that's an agreement that you can come to with an individual to say, I only want this flexible working for a short time. But if a person puts a statutory request in, the expectation is that that will be a permanent arrangement, that terms and conditions of employment will be changed to reflect that, and they will have contractually varied their own contract of employment by their request. Which means that there isn't really automatically any coming back from that. They live with the decision that they've made, assuming that the request doesn't infringe one of the various statutory business reasons which you can have for saying no. And as I say, that those are set out in the More Pay handbooks for you, or you can go on Gov UK and you will find a reference as to what those statutory reasons are. But they're the only reasons you can reject currently. I'm not talking about in the future, currently.
Perfect, thank you, Mike. Another question here. So from Sonia, we are a seasonal business, so we have 0-hour contracts for our workers. How will seasonal companies manage this change? Jill, would you be able to answer that one?
Yeah, sure. So yeah, it's recognised that 0 hours contracts do work for a lot of businesses, particularly like a seasonal one would. But what if in reality, if your season goes over 12 weeks and you've got employees that are working maybe full time over 12 weeks, then they'll need a contract to say that their average hours is 12 weeks. It might be, if it's very seasonal with peaks and troughs, then it might be that you need to move from a 0 hours contract and move to what we call a seasonal contract, which will allow you to have in it things like, oh, in the summer period we'll need you to work X amount, in the winter period then you can drop your hours down to X amount of hours, just so it gives the employee more of an expectation of what their salary is going to look like over the year. What hours can you actually guarantee that the employee is going to get over that amount of time? I don't know whether you want to add anything else to that, Mike.
One thing I would say, again, I've mentioned Ireland, and one thing I find interesting in the Irish legislation that they brought in about 5 or 6 years ago was the ability for a member of staff to come forward every 12 months and say, actually, I think the amount of hours you want me to work is different than that which I'm working currently. And they have what's called banded hours. And I find that quite interesting as a concept, because it runs from sort of 5 or 6 hours through to 35 to 40 sort of hours, and there are bands. And effectively, the employee comes forward, although there's nothing to stop the employer making the offer, but the employee comes forward and says, I think I'm in the wrong band. You agree with them. They then have to go in that band and they have to work whatever hours you want within that band, which can be more than what they've asked for, but as long as it's within that band, that's okay. And then in 12 months' time, or if the business, the circumstances of the business change dramatically, there's an opportunity to review that and go, well, we want to change back. I'd like less hours, or the business is saying we just can't afford to operate like that. The amount of trade has gone down, therefore we need to renegotiate that. So Where the Labour Party and its advisors may be looking, I don't know, but there are models around which won't mean that there are huge burdens on business, but it does mean that some of the present difficulties could hopefully be addressed. And what I've got in mind when I say that is that although there's something like 4 million people more working in the economy since 2010, about 1 million of those, it's difficult to put a number on it, but about 1 million of those are what they call gig workers, 0 hours, casual work, that sort of stuff. And what the government is saying is they want people on predictable amounts of work and a predictable economic outcome for them, so that they can look with some certainty to be able to afford to rent a house or buy a house or whatever it is that their economic priority is, go on holiday, whatever. And it's how you marry those two things, where you've got, on the one hand, a government that's very keen to stick by the idea of flexibility and economic growth, on the other hand, having people who feel that they're part of a workforce where they know what they're going to get at the end of the week or at the end of the month, and do away with some of the uncertainty of gig working. But they're not, and they don't appear to be saying that things like casual work, that there isn't a place for it. But it might be that there's more restrictions or models, as I say, such as that having the Republic of Ireland, where they've tackled that in a slightly different way.
Perfect. Thank you so much. We have a question here regarding unions. So the question is there a requirement to have a statement in contracts of employment to confirm right to join or right for free association?
No. What there is you have to indicate whether or not there is collective bargaining or there is no collective bargaining. And again, if you're using more pay written terms, that sort of clause will be there for you. If you want to put additional information into a contract of employment, there's nothing to stop you doing that. I'm not so sure about freedom of association. You're sweeping into a very wide area with that sort of wording. But if you, I think I would probably find or expect to find clauses about how collective bargaining might work, or even certain employers encouraging people to be a member of a union, and that normally takes place in either large-sized private sector employers or more normally in the public sector. So as I say, no, but yeah, there's nothing to say that you can't if you don't want to.
Perfect. Thank you, Mike. We have a few more questions in the chat panel. We do have a little bit of time, so if you have any pressing questions, then please do pop them in that Q&A panel. So we have a question here from Bill, which is, in the NHS, HR have to consult with union colleagues in joint partnership meetings on policy revision and update. And a lot of time and planning is required for this. So his question is, what's the panel's advice on the given the impact of the new legislation on HR policy and procedures NHS employers will face?
That's I think impossible to answer. We're going to need to see some more of the detail sweeping out of some of the things that at the moment are just aspirational or bland statements without an awful lot attached to them. I think we are, by inference, if we look at the sort of wording that Keir Starmer is using, so he's coming out with phrases like a new partnership between business, trades unions and working people. And I think business you can read in the widest context to include large sectors of the NHS, the teaching professions and so on. Let's think of it in that way. And he's saying we want this partnership between employer organisations, shall we say, and also on the other side, trades unions and working people. What that will translate into, where he's also saying that we want to see good faith negotiations and partnership, how all that will translate in very drilled down detail of what you currently operate within one organisation as distinct from another, it's difficult to speculate about. I would hope that certainly in terms of organisations like the NHS, that what it would translate into is actually having discussions where the people that are sat around the table have got the opportunity to reach agreement. I think one of the big problems that as somebody who observes things from the sidelines sees is people sat round tables who don't have the authority to reach agreement, and whatever they can do to improve situations like that, I think they're signposting that that's where they want to go. And it will be interesting to see, for instance, what Wes Streeting does in the context of the juniors doctors dispute. That might give us some clues to be able to answer your question. Not that it's a case of saying, right, the unions are right and they're going to get whatever they want, but rather, how can you achieve an agreement in a body like the NHS, which is potentially going to cost a lot of money, but at the same time, we've got an incredibly creaking, groaning and broken NHS, which is something that virtually everybody in this country loves and wants to preserve. So how do you do it? And how do you do it without raising taxes? So I don't think I'd like to have his hat on at the moment, but I do hope and wish him success in trying to resolve that. And I'll be looking closely over his shoulder at what he's doing and what he's saying, and seeing whether that rubs off in other industrial environments in the not too far distant future.
Really interesting. Thank you, Mike. So we have a question here from Sally. Sally has asked, on 0 hours, we have employees who work on service replacement, so that hours are very variable. How would this work?
Just go through that again for me.
I think I've got that, Mike.
Have you?
So
right.
if the hours are truly variable, then they'll just continue on a variable hours contract. The idea behind this new bill is to stop the exploitation of 0 hours contracts. So it's just to make sure that everyone's got a contract that reflects what's actually happening in practice. So if your employees do need to work variable, then you can keep them on that variable hours contract. The idea is, there are some industries where they've got people on 0 hours contracts, but actually they're working full time on a regular basis, and they've kept them on that 0 hours contract just in case they need to pull the hours at any point. But if you are truly working variable hours, the hours vary from week to week, month to month, and you can keep them on that variable hours contract. If you know that you're going to need them for at least 10 hours a week, then you're better to put them on a contract that says we need you for 10 hours a week. Then that employee knows that they've got at least 10 hours of work. You know that you've got that employee for at least 10 hours.
Perfect. Thank you for answering that, Jill. Okay, we've got a question here from Annika. Annika has asked, will the duty to prevent sexual harassment come in on time, as there is still a lack of detail what employers need to do to meet it, and it doesn't really give employers a lot of time to action any of it?
Yeah, that's a very good question. I hate people who say that's a very good question, by the way. Again, it's scheduled to come in October. There are elements of it where, in terms of the manifesto, it was being said that they want to strengthen it, and Gill's already referred to the potential for third-party harassment to come back in. It's now complicated and compounded, and there's a few of us banging our heads against the table and wondering where it's all going, because the Equalities and Human Rights Commission has just published draft guidance comparatively recently about the bill, and there are a number of areas, and I've got to be honest in that I haven't yet had time to read all the guidance through in detail, but there are a number of areas where they're flagging up third-party harassment issues. Now, given that third-party harassment was taken out by the House of Lords way back in the parliamentary negotiation that went on, and it's managed to find its way back into the guidance. You do wonder exactly where all this is going to end up. As best as we are aware, it is still going to come in at the end of October as projected originally, hopefully with a finalised version of the guidance that will live with it. But we honestly do not know what the government is now going to do to maybe at the margins, or maybe more fundamentally to take another look at some of the provisions that are in that legislation, or indeed to bring in something else in addition. We don't know that yet, and we won't until the detail starts to pan out in terms of the Employment Rights Bill.
Great, thank you, Mike. A question here from Dean is, if an employee fails their probation period following a structured approach with milestone meetings and documented reviews, and their work is not up to standard, will you be able to then terminate that employment due to a failure of probation period?
I can pick that one up. You go, Gill.
Yeah, sorry, just going to say, they've made reference to it within the bill, but they haven't, which implies there will be some sort of process that we're allowed to do for probationary period, so that will shorten the normal disciplinary process. But what that will look like in practice, we're not sure. There's just no detail of that as yet.
Thank you, Gill. Question here from Liz. How will the day one protection for employees impact the ability to dismiss within a probation period?
That might be the same question put another way round, but
yeah, you're right.
we simply don't know as yet. The guarantee at the moment is that probation periods will be allowed, and that's very wise. I think as a practitioner, and we advise clients on this all the time, what I would say is even now you need to use probation wisely and use it properly. And believe me, I wish I had 10 quid for everybody that just let a probation period run through and then the individual just ended up employed by that business and then something went wrong. I think it's far more likely, as Gill's speculating, but we do not know as yet, that there may be a more structured process that you have to go through. At the present time, you don't need to go through a formal process. You use the probationary review mechanism, and if things aren't working out, the employee can say, or you can say, things aren't working out, sorry, we're going to part ways. And it's not a particularly structured approach in the way that, say, a disciplinary process would require, with ultimately a right of appeal and unfair dismissal and provisions in potential and so on. And until we see what it is that the government's got in mind for this, we won't be able to answer authoritatively that particular question.
Great, thank you. We've just got time for a couple more questions that we can squeeze in. So we've got one here in relation to SSP charges. So if the earning limits and waiting days change, is it likely to increase the SSP paid by employers, hence additional costs? Is there any likelihood that the government will reimburse employers for SSP in the same way as SMP, for example?
Well,
yeah.
I'll pick that up. It might be Gill might want to add to this, but certainly I think the blunt answer is no. I think that given government way back when used to assist in making payments when you could reclaim costs of SSP, and they took that away, unless the current government has found some deep pockets that it keeps saying don't exist, then I would be incredibly surprised if this was anything other than a burden potentially for employers to have to pick up. It may not be massive, but it's still potentially significant. And again, I know this is, I must stop taking my holidays in Ireland. I'm going to reference across. Until 2 years ago, 3 years ago, the Republic of Ireland did not have any statutory sick pay. There was a social benefit effectively that you could obtain, but they didn't have statutory sick pay. They now do, and it was originally 3 days. It's currently 5 days. It's going to go to 7 days, and then it's go to 10 days. Now, I think we go for 28 weeks or thereabouts before it runs out. But what I want to mention is the difference in money. So in the UK, in approximate terms, what you would give an employee by way of SSP in a week, if you went across, and do check me out on this, if you may not want to believe it, if you went across the Irish Sea and you were in Dublin and you were giving an employee their statutory sick pay, you would pay approximately in a day what in the UK you pay in a week. So somewhere along the line, there is a difference in value put on sickness payments. And whilst we may find them here an imposition and likely to get more on business, it's not anything like what's expected in the Republic of Ireland in the last few years. And it seems, I mean, there haven't been riots from employers. A lot of disgruntlement, undoubtedly, but you know that they seem to have managed to get away with it, which surprises me in a lot of ways, given the significance of the amounts of money involved. But there you go.
I'll just say to that, it might well and result in you having higher short-term absences of like 1 or 2 days. So what we'd suggest is that you make sure you've got a robust absent management scheme so that you can tackle anybody who may not be taking genuine sickness absence.
Perfect. That's a really good point. Thank you, Gill. We have had some really great questions come through. Thank you so much, everyone. I'm just going to squeeze in one last one because it is a great question. And I'm going to give this to both Mike and Gill. So Kelly has asked, if there is one key thing that you would advise HR/employers to get ahead of the game on, what would it be?
Okay, I'm gonna pick the one that I think I'm jumping in, Gill, and I hope you don't want to pick the same as me. It's like family favourites, isn't it? Where I pick the one that you were going to say. I think that's causing employers the most concern is the idea of day one unfair dismissal provisions, and I can't say that there's an easy answer to that. But what I would say is I'd be keeping a very close eye on the developments of that. And I think through, obviously, we've got hundreds and hundreds of people on the line today, through your MPs, through your trade bodies, I would certainly be saying, make it clear that there need to be clear exceptions to this. We need to be very clear that if somebody is a casual worker and you engage them for 1 day, because there was a little job to do and you gave them that assignment, that doesn't give them an automatic right to claim unfair dismissal because you only wanted them and only ever intended and they only ever agreed to 1 day's work. We need to be clear that if you can employ someone for relatively short term, and that might be, say, less than 2 years, a temporary contract or a fixed term to cover maternity, 12 months, something like that, that you're able to bring those sort of provisions to an end without getting off into a, well, you were required to keep me on and I'm now claiming unfair dismissal. We also don't want to see it clogging up the tribunal system. The tribunal, the employment tribunal system is already creaking and groaning now. The thought of another huge raft of claims around unfair dismissal could completely break it. So I think that whilst you can understand the wish on the part of the government to change things, that I'm not sure they've really, and I know it was a party policy rather than a governmental policy, that they've not really necessarily thought it through. But as I started out with, and probably it's going to be my last contribution, this is actually the one that would be easiest to change. So we need to watch out, and you need to be able to respond and get onto your MPs, who these days are quite likely to be Labour MPs, about this, because certainly in my time, I can think when the period for unfair dismissal has been 6 months, I can think when it's been 12 months, and of course currently it's 2 years, and now we want to move to 1 day or 0 days. So it would be very easy to change that legislation without having to have huge parliamentary debates about it. And, you know, that's why, for me, that's my favourite that I would be wanting to keep an eye on.
Yeah, I'd 100% agree with that. And I think in terms of getting ahead, all you can do is look at your recruitment processes. Are you attracting the right people? How you're monitoring people, especially in that probationary period, and making sure you've got checks in place to make sure that you're having regular one-to-ones in that probationary period, and if things aren't right, that you're taking action within that time.
Brilliant. Thank you so much, both of you. That was a really great Q&A session and just a brilliant webinar. Thank you so much. Just before we say goodbye, I'd just like to point everyone in the direction of our Knowledge Centre, which is really easy to find in the menu on our website. It's really packed with lots of helpful resources, including upcoming webinars, guides and blogs, plus everything is free to download. So please do go and check it out after the webinar because there's so much content in there. And finally, if you would like to find out a little bit more about our HR and employment law services, please do drop a message into the Q&A panel and one of my colleagues will get in touch with you. Our HR advice line runs 24/7, 365 days a year, so no matter when an HR issue crops up, best practice employment law advice is always available over the phone, anytime, delivered by our highly experienced team of qualified experts. So before we finish, you will see a prompt to fill out a poll when we close the webinar. So here we're just looking for some opinions and some insights to help us tailor our research, resources and content for our listeners and readers. So if you have got a few seconds to complete that poll, then we'd really appreciate it. So that is everything from us. Everyone who has attended today will receive a recording of the webinar and a copy of the slides. I'll make sure to send those out before the end of the day today. Thank you so very much to Gill and Mike for hosting today. You've been absolutely fantastic. And thank you to everyone who has joined. I hope you found this session useful and I hope that you have a lovely rest of the afternoon. I will now close the webinar. Thank you.